7 p.m. Sunday night, Expropriation Act in sharp focus. Let's get to it. It's Topical. It starts right now. A very good evening to you, South Africa, those watching around the world. My name is Blaine Herman, and this is It's Topical. Our digital audience with us tonight, popping up on your screen in a short while, joining us from the University of Pretoria, UJ, UKZN, and NMU. They will weigh in some of the burning questions they have for our guests in a short while. The Expropriation Act met with mixed reactions. It repeals the pre-democratic Expropriation Act of 1975. It sets out how organs of state may expropriate land in the public interest, underline that one, for varied reasons. Now, basically, it outlines how expropriation can be done and on what basis. Local, provincial, national authorities will use this legislation to expropriate land in the public interest that seeks to, among others, promote inclusivity and access to natural resources. Some have welcomed the act. Some believe it doesn't go too far. Others believe it goes too far, right? Is the Expropriation Act on solid or shaky ground? Could it land up in the courts? Our guests tonight are representing the Democratic Alliance, the Economic Freedom Fighters, the PAC and Rise Mzansi. We invited the ANC. They could not make it. It leads us to the question of the week. We're asking you, do you think the Expropriation Act of 2025 is a step in the right direction? Simple question, complicated answers. Let us know at SABC News_TV. Let's walk and talk. You know the route by now. We want to get you more context, right? Section 8 of the Constitution talks about the Bill of Rights applying to all laws, right? To what extent does the Act comply with the Bill of Rights? Let us know your thoughts at SABC News_TV. Perspective coming up. All right, let's get you some context. And as always, we turn to the magic wall, what we know and why it matters. Now, you've heard the presidency, right? This act is meant to guide the processes and procedures for expropriation of property by organs of state. And in terms of this law, an expropriating authority may not expropriate property for the purpose other than a public purpose, or, in other words, in the public interest. We'll explain in a short while. An expropriation may not be exercised unless the expropriating authority has, without success, attempted to reach an agreement with the owner or holder of the right in property for the acquisition thereof on reasonable terms. What does that mean? We'll explain in a little while. So, an expropriating authority is therefore obliged to enter into negotiations with the owner of a property required for such purposes. What does that all mean in practical terms? Let me bring in our guests to help me break this down. Bulelwa Mabasa is the head of land reform from Waxman's attorney. She joins me now live. Thank you very much indeed for your time.
Wonderful to be with you.
We need your better mind to help us understand this. Land audit. We want to make full use of the land in South Africa. Do we know where the land is available and who owns it?
There was an attempt in 2017, as you correctly point out on the screen, where a national land audit was conducted.
Right.
However, various holes were poked into the audit for various reasons. A, we don't have an asset register in South Africa where landowners are stipulated in terms of race or gender and so forth.
Why
we
not?
also have, because we just don't have the legislation that requires that to happen. But secondly, we also have a lot of private land that is held in trusts and other corporate entities,
right,
where you cannot ascribe a certain race or even gender.
Yes.
And so the criticism that was laid on the 2017 land audit report was that it was not reliable, and that we actually don't know who owns what land in South Africa. So as much as we have the statistics that you've shown, yes, for the 2017 audit, we don't yet have a mandatory system in South Africa where we know the race and the gender or otherwise of landowners.
So this Expropriation Act doesn't force or nudge government into getting to that place where we do know.
Look, there were attempts before in various bills where it was called the Agricultural Holdings Bill, where they tried for people to come forward and declare what land they own, especially private land and so forth. But that bill never made it. It didn't see the light of day.
All right. Now I want to talk about the contentious issues around the expropriation bill, the preliminary steps to expropriation. What are those steps? Take us through it.
Look, as it correctly points out here, is that the first thing that an expropriation authority needs to do is to establish whether or not the expropriation is in the public purpose. Now, a public purpose, Blaine, are things like building a hospital.
Right.
The Gautrain is one such example. The 1975 Act was used, actually, to expropriate property that was subject to the Gautrain. Things like hospitals and schools, that's clear enough. That's for the public purpose. Interestingly, in South Africa, we also have what we call public interest.
Right.
And that's a specific, unique South African inclusion that is not necessarily contained in other expropriation clauses in other parts of the world.
Right.
And public interest in South Africa is defined as the nation's commitment to land reform. And
now,
so
that becomes interesting, right?
Yes.
Do you expect a lot of legal challenges coming from here?
Look, I don't expect that building a road or rail or a renewable energy infrastructure for the benefit of the nation would be contentious, because that's self-explanatory. Public interest, on the other hand, if you unpack it based on its definition in the Constitution, that's where we talk about land that is required for redistribution purposes. And that is a constitutionally mandated function. Redistribution and land tenure, for example. So that to me, although it might sound subjective, if you look at it plainly, we have sufficient legal jurisprudence that will guide whether or not an expropriation is indeed in the public interest and in the public purpose. So I personally am not concerned around that, because I think the legal principles are well established.
Right. So it looks like there's a number of steps before we get to finality. Is this likely to take a long time to solve?
Look, firstly, it depends on how well-resourced the Department of Public Works is going to be when it comes to this level of, implementing expropriation in general terms. Like I said, we've had the expropriation in the 1975 Act. But I think this particular Act of 2025 does introduce layers of more consultation, which is obviously in line with the promotion of administrative justice principles in our law.
Right.
So consultation here means that the expropriation authority can't just come and say, we're expropriating your land. They've got to first send a notice of their intention to expropriate. They've got to show that they've done their research in terms of the suitability of the land for expropriation. What does that mean? Well, they would need to get reports from municipal managers from municipalities. They would need to get a report from the Department of Land Reform, the Department of Environment, and so forth. So it's a very consultative process. And actually, the landowner can even object to the basis for the expropriation. The Act does make provision for that.
So that then goes to court?
No. There is a mediation process that is built into this new Act, where parties are able to call upon their respective experts, where they negotiate and they come up with hopefully a solution in terms of whether or not the landowner is the willing seller. And if not, the ultimate decision maker are the courts.
So this, with all these steps, realistically, this is likely to take a long time. And that's one of the criticisms, isn't it? Justice at a pace.
Look, I think justice that is not done procedurally, fairly, is no longer justice. So we've got to exercise our minds in such a way where we say, if the expropriation should happen, it should happen in a just manner, with procedural fairness built into it. So yes, it might take a long time to achieve, but I don't think that it's something where we want to take shortcuts and then end up with an unjust situation.
Right. Now, this is also the contentious issue, right? Section 12, subsection 3, talking about expropriation as well. Let me get to that. This is the with nil compensation. Is there a difference between nil rand compensation and no compensation?
Look, nil compensation is expropriation without compensation after a certain methodology has been, or after certain factors have been taken into account. For example, nil compensation is expropriation without compensation, where they will look at the current use of the property.
Yes.
You look at whether the history of the acquisition of the property. So was the property purchased before? Was it a donation from the state before, during the apartheid government? Was there any direct state investment in the purchase of the property? And so forth. So nil compensation says it's when you've taken all these factors into account and you come up with a figure, having taken each case on the basis of its own merits and its own facts. May lead then to no compensation.
Right. Illegally obtaining land or property. Will that lead to no compensation?
Once you also take into account all the other factors. So if you look at market value, for example, if the value of the property is less than what the property owes in terms of rates and taxes, its market value would be less. So if you count all those steps, it is possible, but in very rare circumstances, where you can actually reach a zero kind of outcome.
That's an important point. How far can it stretch, though? In terms, can it go to colonial times, if somebody can prove that their land was stolen, basically?
Look, that's when it gets a bit complicated, and that's when reliance has to be on historians. Reliance has to be on the reliability of a deeds registry. How far can it go? How far are the records actually to show that? And you'll remember, especially with for example, the Natives Land Act, when black people were dispossessed of land illegally, unlawfully, and without compensation. But it is highly unlikely that anyone would be able to prove such if we're to rely on archival material or historical documents.
Thank you very much indeed. You value added, no doubt. We're going to continue this conversation. All right, that was Bulelwa Mabasa. She's the head of land reform practice at Waxman Attorney. Now, I want to give you a sense of what you're telling us. The Word on the Street feature took to various streets in Gauteng seeking diverse insights and perspectives on this topic. And this is what you had to say. Watch.
I feel like it's going to be like a benefit, more especially to the black people, not only black people, but for the fact that the land will be seized equally. That will benefit them in terms of productivity, job creation, because they'll start their cultural thing, which is, we talk about like farming, doing some job creation, but due to the thing of not having a land that they can own, I think it's one of the factors that stop them from building something good for themselves.
The state owns so much land that is lying idle. It would be far better if the government focused on doing something productive with the millions and millions of acres and millions of rands worth of land that it holds at the moment that is doing nothing.
They went further to explain themselves to say, for a landowner to be able to release land, court must intervene. So there is no way forward. There is no direction. It's the same thing. We're still running into circles.
I'm in favor of expropriation to a certain degree, but with full compensation where it's merited, where it's deserved.
All right, let's get this discussion on the road. We got a packed house today, so I want to introduce my guests from the Democratic Alliance. We have Karabo Khachao, Lubabalo Ncholo, represents the Economic Freedom Fighters. Eddie Mfulwane is the Deputy Secretary General of the PAC, Mahashula Ghana, Rise Mzansi Caucus Whip. Thank you so much. Bulelwa Mabasa is still with us as well. So she's going to add her important input in terms of what we're dealing with the Expropriation Act. Our digital audience as well, please, if you have any questions, please raise your virtual hand and I'll do my very best to get you on air. Now, Karaba, maybe I'll start with you with regards to the DA launching this formal dispute within the GNU. Tension is probably an understatement at this stage. There is a cabinet lekgotla that's coming up. Do you think it's going to be a make or break for the Democratic Alliance, given the GNU?
Everything will be a make or break for as long as the president doesn't come to terms with the fact that he's not alone in government. He is not leading a cabinet of solely the ANC in it. And for as long as he doesn't come to terms with the fact that the Democratic Alliance did not enter the government of national unity to just simply copy, paste and roll out ANC policies. We campaigned very strictly to the Republic of South Africa to say that these policies have failed South Africans in the last 30 years, instead of helping them out. And we went in there to try to make sure that we have the best representatives available for them to dial down the mess that the ANC has been for South Africans. And so it is disingenuous also of the president and completely mad, actually, for a lack of a better expression, for him to pass legislation without having a consultation with his GNU partners, particularly his biggest partner within the GNU, to make sure that by the time he signs this bill, everybody is happy with it. And more so, because constitutionally, we are still of the belief that this bill does not meet master, which is legal advice that the Minister of Public Works and Infrastructure, that the Minister has given to him. And he still continued to do so, and we all woke up on social media to learn of these news. And apparently his political party also woke up to this news on social media.
Well, just bear in mind, we did invite the ANC as well. They couldn't make it. But this must be highly confusing for the public. I mean, we had Dean McPherson. I think we have what Minister McPherson had to put it up, Kani, give the viewers a sense of what we're talking about, writing on X, saying that as the Minister of Public Works and Infrastructure, there will be no expropriation of private property without a compensation on my watch. The guarantee of property rights under Section 25 of the Constitution is not up for debate and is non-negotiable. Now, then you have his deputy, Sihle Zigelala, writing on X saying, we stand ready to defend the Expropriation Act and ensure its timely implementation. Eddie, how should the public interpret this mixed messaging?
Look, firstly, we must appreciate that GNU consists of people who source their thinking from different frameworks. As a result, partially I agree with my sister, consultation is very key in the whole process. However, managing tensions, contestation of ideas, that's our everyday work as leadership. So whether Sihle's tone is high, whether McPherson's tone is low, whether what they say on tweet, that's them expressing their views. But the reality is that we have structures set in place. There is a cleaning house, that is a committee that is all leaders represented from all political parties represented in GNU. If you have a crisis, there's no need for you to stand up and throw your toys in public in tweet. I said it previously, that very disappointing from the two seniorest leadership, both DA and ANC. They are the ones parading our internal disputes in public.
Karaba, are you playing politics?
No, look, we're not playing politics with the lives of South Africans. And that's why, instead of throwing our toys out of the quarter, as my sir says, we have made a request to the president to say, South Africans deserve a government of national unity that works. Let's sit around the table and make sense of the policies that govern and the laws that govern this country. And that's why, soberly so in the best interest of South Africans, we've asked you to deal with the inconsistencies within the Act as far as constitutional master is concerned and procedurally. We've asked to take the bill back to Parliament so that we can soberly apply our minds to it, and so that South Africans at the end of the day don't have to sit like tonight and watch a conversation about confusion in government.
You would assume, Lubabala, that this piece of legislation has gone through the best legal minds before it got to this stage. Why is this an issue? Why are you calling it a legislative cop-out?
Because that's exactly what it is. And I feel the debate we are having now is completely unnecessary. Primarily because the Expropriation Act and attempts to develop expropriation legislation that is in sync with our constitution from as far back as 2008 has always been about making expropriation aligned to the 1996 constitution. It does nothing further than that. If you take the 1975 Expropriation Act and this new act, I highlight that there are just 4 differences here. The first one is that it does make provision for a just and equitable compensation for expropriation. It creates this legally absurd concept of nil compensation, which I hope we'll have time to unpack later on. And I think it makes provisions for the recognition of unregistered land rights as well, which was not there in the 1975 Constitution. Outside of that, there's nothing substantively different from the 1975 Constitution. It doesn't take us anywhere. Right. We're still stuck there. So the debate that has been raised by both the right-wing elements in society and those in the ANC who are trying to pull wool over the eyes of our people that this will take the fight to get our land back further is basically rubbish.
Makashilagana, does it go far enough for Rise Mzansi?
So thanks very much. So as Rise Mzansi, as you'll know, we have come out in support of the Expropriation Act. And one of the things that we've been saying is that there's been a lot of fear-mongering that's been happening in society. Not like I was listening to people saying, no, your homes will be taken and will be expropriated without compensation. I was like, you are not reading. If you read the act, which if you understand why the purpose of this particular act is to bring it in line with the 1996 Constitution. Because the 1975 Act, Expropriation Act, was done before the 1996 Constitution. That's why even Lubabelo raised the point around the just and equitable, because it was not there. Where we have a situation of expropriation, which in any case, it is expressed in the Constitution of the Republic. So when people now all of a sudden wake up and say, no, we are surprised that there's expropriation and that property is not limited to land, I say, but property was never limited to land in 1996. So all these manufactured tensions, that's what I call it. It's manufactured tensions.
Why do you say manufactured tensions?
It's manufactured because, you see, this piece of legislation was passed in the last parliament. So everyone knew when parliament dissolved at the end of the term that there's this piece of legislation that's in front of the president. You cannot then say the president must negotiate. Negotiate under what law? There's no space for any negotiation. The president can only sign or return it back to parliament. But in returning it back to parliament, he must say, all right, you as parliament, this particular clause that you have drafted, I don't agree with it. Yes. And in any case, I must say this, in any case, if any South African that believes that the Expropriation Act is unconstitutional, let them go to court.
You going to court?
They must go to court.
That is why we're going to court. And there are 2 reasons, constitutionally and procedurally. Constitutionally, the modus operandi on the process to be followed, right, for expropriation, there are 2 processes that are listed within the Act that are inconclusive of each other. So there is confusion itself on whether we're seeking the counsel of the court ahead of time or afterwards. The second problem we have constitutionally is that it is unfair and disingenuous of the ANC and the president to put the onus on individuals to seek the counsel of the court should there be disputes and disagreement, irrespective of on which side of the negotiating table you sit.
So where does the onus fall?
On the state, because the state must bear 100% responsibility for successful acts of redress, land reform and restitution, full stop. Number 2, on the point of procedural problem, you would note that in the previous administration, the Democratic Alliance objected to even the process itself because in the NCOP, 3 of the 7 provinces that voted in favor of this bill, being the Eastern Cape, Limpopo and Gauteng, their negotiating mandates were flawed because they didn't hold their sittings of legislature. So they went to the NCOP without negotiating mandates itself. And that's not how things work. So if we as a government of the day are going to expect South Africans to take the laws that govern their lives seriously, the bare minimum that we can do for them as politicians and public representatives is to make sure that procedurally we get things right, and two, to make sure that the laws that we give up to them meet constitutional muster. And that's why we are asking. We're not saying don't expropriate because we are in favor of Section 25 of the Constitution. We're saying clear the inconsistencies, make sure that we don't have problems in court, and make sure we deal with justice.
So I'm glad that the DA says that land and property can be expropriated.
Yeah,
because that is very important. Because the fear-mongering that has been going on since Thursday is that no, we don't like anything to be expropriated. That on record now, it says we can expropriate and just and equitable compensation must be paid. And in a case, and what she's saying is that she doesn't want the court to be the final arbiter.
No, that is not what I'm saying.
So Section 25,
no,
Section 25 says the court, if in a case where we don't agree on the amount to be paid, the court must then decide, and what the court decides is what it is.
That is the flaw. So listening
she says the state must then be the fight, must carry all the costs.
Clarify your point before I go to
Tatana, listening is a very important skill. I am not saying that the court must not be involved, because that's how we secure fair negotiations. That's where fairness comes from. The problem is the onus of seeking the counsel of the court and the cost involved. That shouldn't be on the shoulders of individuals.
If you had your way, you'll throw this back to Parliament and change the Constitution, right?
No, because we will not throw it back to Parliament. We dismiss the Act completely as is, because it's a sellout arrangement. It doesn't take the struggle for land repossession anyway. Because you know, Dean McPherson said that there will be no expropriation of private property under his watch. There is no provision for expropriation of private property without compensation in the present Act. So it does nothing. It speaks about nil compensation, which I say is a legally absurd term, because expropriation is rooted in the Constitution and it is compensation-centric. That's why, as the EFF, we took our fight to Section 25 of the Constitution, that in order to drive the process of returning the land back to natives, you must change the Constitution, which provides for a false equivalence between the rights of the dispossessed and the rights of the dispossessor. That's the central question here.
Eddie, how urgent is it to change the Constitution, as Lubabalo puts it, as solving the land issue?
Look, as I might say to you, I think me and Lubabalo ideologically we don't differ. And we like saying to people that now we have arrived at the technicalities. At an ideological level, we can speak it in one sentence, slogan here, the land must go back to its people. But now we must get inside the technicalities. That's where we are as the PAC.
Right.
We were very happy that today the narrative and the political discourse and everybody is discussing the question of the land, property ownership patterns. It's not only the land, my brother. The question at the hand is ownership patterns. Now, when we're discussing expropriation, my dear brother, I do not want us to bore ourselves with a lot of nitty-gritties. The intention from our side as the PAC, we accept and welcome the bill as it's signed. We appreciate the snail pace that the ruling party is moving at towards the land question and the ownership patterns. However, from where we stand, now there is a process.
Right.
We are part of the system. We have got the responsibility. From where we stand, we are from an NEC meeting. We resolve to ourselves as a ministry, must have a bill that talks now to how do we enhance the ideology and the land question further.
I'll come back to you, Kuraba. Digital audience, stand by. I'll come back to you. But I just wanted to bring in Bulelwa now with regards to this nil compensation. Yes. I was reading Annalise Crosby. She's the head of the legal intelligence at Agbiz. And she's explaining that nil rand implies that there must be a calculation taking into consideration the factors in Section 25 of the Constitution, which then comes to result of nil rands. Help us understand this nil compensation issue.
So, as I said earlier, the formulation in Section 25.3 in coming up with nil compensation means that you've got to go through a process that involves 5 factors. The first factor that you need to look at is what is the current use of the property. So in other words, how is the property being used? You look at the market value. However, market value is not the only thing that you look at. You then look at what is the history of the acquisition of the property. So was it bought? At what price? Was it a donation? Was it a crown grant? You then look at improvements and direct investment that has gone into that property. And ultimately, you look at the purpose of the expropriation.
Right.
Now, if you were to implement each of those steps, you'll find that there are very rare circumstances that are actually going to lead you to a nil value. For obvious reasons, because most properties will have a market value.
Sure.
And it also then relies on the reliability and the availability of evidence in a form of historical reports.
Right.
What information is there in the deeds registry and so forth.
Right.
So notionally, it might be possible to end up with zero compensation. But I think, as Lubabalo said it very crisply, the concept of expropriation is a global concept that is used all over the world.
Yes.
And inherent in an expropriation, what makes it an expropriation, attached to it is the obligation to pay some form of compensation.
Right.
The difference lies in different jurisdictions around the world. Some even have a concept of a solatitum, which means that you pay extra for inconvenience. But as we said, we have a unique situation that is embedded in our constitution in South Africa, where just an equitable compensation could even be less than market value, and in certain circumstances, even more than market value.
Would you, in comparison, would you say that our act is mild compared to others around the world?
I think that what's happening in South Africa is that we have used the very normal expropriation concept that governments use across the world, and we're trying to use that expropriation power in order to advance land reform, because land reform is a matter of the public interest.
Right.
It is true that expropriation on its own, it's not the only tool or methodology that is going to deliver access to land in our country. It is only one power that the state can use. There are many other issues that should be implemented in our land reform legislation, in our Restitution Act, for example. In land redistribution, we still don't have a redistribution act that tells us who can gain access to land under what circumstances in the form of an act of parliament. I would personally be very excited if we woke up one day and we have a redistribution act, because that's where the lever of moving the needle forward of land reform is actually going to happen, because redistribution will enable citizens that don't have access to land to be granted that access in a form of an act of parliament.
Lubabalo, I know you champion the bit. Stand by. I'm going to come back to you in a short while. I just want to take our digital audience very quickly. Molatelo, let's hear from you. Question?
Good evening, Blaine. Good evening, Blaine. I just have a question here. Well, first of all, I do agree with Makashule in what he was saying, that there is fear-mongering that's happening with regards to this whole land question. My challenge is, I think there's a bit of a political immaturity that is being shown by all these political parties, especially the ANC and the DA, because what's happening now is something that could have been discussed. At the same time, there's also a bit of political psychosis, as we call it, because there are people who are going onto social media and manipulating ordinary South Africans into believing and, saying that the land is going to be taken back and they're going to lose their property, etc., of which is not the case. I think it goes back to just being able to read and reading and understanding.
Let's park it there, Molatelo. We've just got so much to get through, but I get your point. I'll put it to Karabo in a short while in terms of the issue of political immaturity. Ntatoa, let's hear from you very quickly. Your question? If you could unmute Ntatoa. There you go.
Right. South Africa's constitution protects human dignity, and it also promotes equality. However, South Africa remains the world's most unequal country in the world.
Yeah.
And the land issue before us is actually one of the factors that exacerbates this issue.
Right.
The Act before us actually is not different from 1975 Act, and it feels like actually the government is actually maintaining and sustaining the apartheid legacy. That's my contribution.
Okay. Rotandwa, let's hear from you, and then Musa.
Thank you very much. I think just to echo the previous two speakers and the panel that's deliberating on the issue, I think there needs to be there needs to be a distinction or understanding of the purpose of the expropriation bill. And like Ntatwa just said, if it's not different from the 1975 bill, then what purpose does it serve, especially looking at the rights that are afforded in the Constitution? Yes, Section 25, but also the right to equality and human dignity. Another thing is also how the Act should also reiterate the idea of security of tenure, especially for those that have been previously disadvantaged and did not, or their land was taken arbitrarily. Thank you.
Thank you. Musa, your question? If you can unmute, Musa, go ahead.
Yes, thank you so much for the opportunity. I think we need to go back to the 1913 Native Land Act that separated, the land, whereby the minority had 93% of the land, and the minority had 93% of the land, and the majority only had 7% of the land. And I think this bill is another way in which we are trying to readdress, the injustices of the past, in which is entitled in our preamble. Thank you so much.
All right, Musa. I know, Control, we need to take a quick break, but I think we need to get to the bottom of some of the comments that have been made. Karabo, political immaturity. This should have been sorted out before.
But that's what we've been saying. We're saying you shouldn't have, as the president of the nation, Dr. Ramaphosa, went and signed a bill without there being a consideration of the statement of intent that you signed that said that you cannot do such things unless 60% of the partners in the GNU have agreed. That did not happen. And again, I stress, we wouldn't be here all together had the president been able to apply himself maturely in Dean Mafeason's approach in saying to him, as the minister whose department is affected by this, I've sought legal advice so that I can understand the mandate of this properly. The legal advice says there is a constitutional inconsistency here. Please, let's take this back to Parliament. The president just mised.
It is now law, though. Is Dean Mafeason going to implement this?
No, we need to...
He's not?
No, but that's why we've invoked the clause, to say we can't just roll it over and implement it. We must go back and talk about it. But what I also want to touch on quickly is what our land expert has spoken to here, that expropriation is not the only mechanism available to deal with reform. And we know this because Section 25 of the Constitution, even in the past, has given the state sufficient power to do so. And that is why the Western Cape government, the DA-run Western Cape government, has been able to successfully have 84% of land reform farms within the Western Cape. Had Section 25 of the Constitution not given people, the state, enough muscle to do so, then we wouldn't have had a 84% success rate of this in the Western Cape.
The argument being made by one of the digital audiences that this is little is different than the past act.
Well, what will law serve when there's no procedures to implement that law? Its intention is suffocated by lack of procedures. Now, here it was just a technical that was being sorted out. We are not saying the bill is the alpha and omega solution to this crisis, but we are saying it's a step in the right direction. The act has always been existing. I liked what the lady that side was saying, that when we discuss 0%, there are different types. I heard her referencing different types of expropriations. In countries that they discuss expropriation without compensation, reparations are a discussion. The question is, those who are dispossessed cannot compensate the dispossessors. We cannot buy back the land with our taxpayers' money from the people who are saying they took it wrongly. It cannot work. So if we are discussing compensation, then the question is with which resources? Then the question of reparation come to the question.
Right, so the issue of reparation is an action making amends for a wrong.
Yes.
That needs to be investigated, right? Is that something the EFF will support?
What needs to be investigated? We know that it's African people who are dispossessed of their land here, and we know who the dispossessor is. So I'm not really interested in the internal ructions within the government of right-wing unity. We are interested in having the land returned back to its rightful owners. And I am glad that Bulelo has raised the point that Section 12, subsection 3 of the current act is really Parliament and President Ramaphosa legislating a hypothesis, because there is no possible way in which you can get to nil compensation. And Bulelo will know the Hilden Hayes formula. The former judge of the Land Claims Court had dealt with this matter of evaluating the factors in Section 25, subsection 3 of the Constitution, which must be taken into account when calculating compensation. And he found that of all the factors listed there, the only quantifiable one is market value. That's why the ANC has been paying 2 billion rands to a single owner for land restitution, for instance, because there is no other possible way of doing it. And that is deeply embedded in Section 25 of the Constitution.
How do we get to the bottom of this, Makashule Gana? I remember listening to some of the sentiments expressed during the public hearings, many arguing that indigenous people's land was taken without compensation. Some farmers are saying that there's a misconception, not all land was stolen. How do you get to the bottom of this?
So one of the things that obviously the responsibility for ourselves as leaders is also to interpret the legislation correct, but also to understand. So one of the first mistakes that the government did was to adopt a policy of a willing buyer, willing seller, which this particular act tries to rectify that, to say, actually, if there's a piece of land that needs to be used for public, in the public interest, the seller does not have to be willing. That's why you have an expropriation, because expropriation, what it means is that the seller might be unwilling. So the adoption of the willing buyer, willing seller, which was not...
well, wasn't even in the Constitution, isn't it? There's a policy interpretation.
So it was to try and, let's call it, massage what the political dynamics in the country. So now we have a tool. What it needs is a political will. One of the things that we have said as Rise Mzansi is that the president is the executive president. He must show leadership. It cannot be stuck in a perennial consultation. If, as Parliament, myself as a member of Parliament, we have passed a law that goes to the president, it's not subject for further consultation, because consultations will have happened in Parliament. So if something that is before the president, the state law advisor says it passes the constitutional muster, the president must sign. We are not in favor of these constant consultations, never-ending ones, when there are many needs that South Africans need. And this Expropriation Act, we commend him for signing it, and we look forward to all the departments, the ministers, to implement it in full. And those who are against it, they must go to court.
Lubabala, hold your thought. I need to take a quick break. When we come back, look, there's lots to discuss. The question, the umbrella question we're asking you is this act a step in the right direction? It's a simple question, complicated answer. More next. Welcome back. You're watching It's Topical. Question of the week. We're asking you, is the Expropriation Act a step in the right direction for South Africa? Let us know at SABC_TV is where we're at. Before the break, Lubabala, we were talking about the issue of willing buyer, willing seller. You have a take.
Yes. Yeah, so I agree with Makashule that the concept of willing buyer, willing seller was not legislated anyway prior to this act. But in fact, it is now legislated under this act. If you read Section 2 of this act, it says that expropriation can only happen once there is demonstrable evidence that the state had thoroughly engaged with the owner of the land and that there could be no consensus reached. So the state is still required to go and thoroughly engage with the owner of the land so that there can be consensus.
Bulelwa, I just want to get Bulelwa, is that accurate?
That's accurate, but I think, Lubabalo, that is necessary, because if you recall, we have Section 33 of the Constitution, which says that any person that takes an administrative decision has to do so in a manner that is procedurally fair. So embedded in our Constitution is procedural fairness. And so if you take away the right of the owner to be able to negotiate with the state, you then have a situation where that very same act could be unconstitutional on the basis that it's the state exercising autonomous power. So I don't think that the consultation element of the act weakens the act. I think it strengthens the democratic state that we've adopted, and that is what the Constitution would require.
Yeah, so there's a conversation that we're not having. So apart from the act, land reform is something that can still be able to happen even outside of the act itself. The state has always had land that it has in their land bank that they can give out to farmers and upskill them and make sure that they're able to participate economically. What we've seen in the past, however, is that of the 2.5 million hectares of land that the state has given, they have done so without security of tenure in most instances, right? So it means that the people who have been there are pretty much tenants. And this obviously then chases away investment. It does not give them security of economic participation. It does not give them security of economic of productivity, which goes against what we want to do as a democratic government altogether. And that's why it's the Democratic Alliance at the very beginning of the land conversation in this country, we've maintained that Section 25 of the Constitution has always given the state sober muscle to make sure that it rolls out and capacitates farmers in cases of commercial land to find satisfaction within our country, to one day be able to leave something behind for their families and their kids that they can be proud of. And that's something that a democratic government has always had the responsibility of. And it's something that Ntatenyonzo of the PAC should have taken up as the first thing when he got into that office. But Dr. Van Dijk, we're here to hear what is going on. And it is incumbent on him to do so that agriculturally, even the Minister of Agriculture himself can be able to support agriculture farmers accordingly.
As the PAC, we welcome the signing of the bill with its shortcomings as they are.
Fundamentally, though, what makes it different?
Well, look, it allows the process. It explains, it clarifies the process. There's always been excuses about the process. Now we have a process. We are not saying this is the best, but we have a process. Number two, Sis Bulelwa, I'm here live to you saying, hold us accountable. A redistribution bill will be before your table and your eyes, in the public's eyes, very soon. It's an NEC resolution of this weekend.
I avail myself to engage with the minister on the redistribution bill. It's been a long time coming.
We're up to the task. Lastly, my brother, we humbly would want to call for political maturity from our two big players in the GNU, humbly appealing for political maturity, in the sense that whatever they are doing publicly has no bearing positively in the process. We have a situation that requires of all of us to live up to this. Leadership must prevail, not some Twitter gimmicks of people just harnessing their egos.
Makashulagana, to what extent is the land issue being seen along racial lines and polarizing society?
It has always been seen along racial lines for obvious reasons. One of the things that we must not do, even when we engage on topics like this, is to not take account of our history. We come from a history of some serious racial divisions, where people were uprooted from the land that they were staying in, they were farming in, and we need to redress those. So we must never get to a point where mechanisms are introduced to redress those imbalances, then there are all this scare and fear-mongering. You know, like I hear this thing, investors. I'm like, since 1975, there was an expropriation bill in South Africa. So are you telling me that these investors have been so scared in South Africa since 1975? Or now they just wake up in 2025, they are so scared? Because if we start telling the truth, and we have a responsibility to lead, we must be able to say, you have a home, no one is coming to take your home. You have a farm, you are producing cabbages, oranges, apples. That land is in use. Like Babalo was saying, that land is in use. No one is coming to expropriate that land. The land that is being expropriated, and it has been done in Gauteng. When Gautrain was built, there was land that was expropriated. Actually, in the Western Cape, there was a case between Shoprite and the Western Cape government in 2022, land was expropriated. So in the public interest, land will be expropriated. But when we go on as political leaders, we create this fear that investors will run away. I'm like, so These investors, they haven't been running away since 1975. Yes. They didn't run away in 1996 when Act 108 of 1996 was passed. Now all of a sudden, when a mechanism that then says this is how land expropriation will happen, now we are told that investors will run away.
No compensation dramatically affecting the economy. Is the economic freedom fighters concerned about that?
We're concerned about historical justice. We are concerned about addressing historical injustices. And we understand that the nature of our economy is still a neo-colonial nature, dictated to by the interests of the market and racialized interest of the settler community in this country. So in order to get to where we want, we are willing to do whatever it takes. And as Makashule has said, the land question stripped to the bone has always been about race. It is essentially about who, between the settler and the native, owns this territory we now call South Africa. And that's what we need to address. We need to address the national question here. Before we engage in semantics of procedure and all of that. But I'm actually shocked that the Pan-Africanist Congress of Azania is aligned to the 1975 Expropriation Act, which provided the procedure, by the way, because the procedures have always been there for expropriation. So they are only concerned about the procedure, which have always been there.
Eddie, respond, then I'll take you up.
My dear brother, we've been long in this discussion of land. You are newcomers. we have stopped the business of sloganeering. We are now in the business of attending to the technicalities that affect our people on an everyday life. Standing up there, raising slogans about land must be taken forcefully, whatever it takes. We are not addressing what exactly is holding us back. What is holding us back is technicalities inside the act. That's what we're supposed to be.
What technicalities does this act address?
Well, my dear brother, let me say this to you. If we as the PAC were government, we would have a different bill, we would have a different law, right? We would want full ownership of the land. But we appreciate the democratic setup we are in. That's what we are humbly appealing from at DDA. They were part of Parliament. Parliament is part of the democratic process. This bill passed the test of democracy in Parliament. Now, when the president is signing it, they speak as if the president woke up one morning with the bill from it to the House and went to Mahlamandla to sign it.
Even to the House doesn't even know nothing about the bill.
The call is for political maturity. What does that mean to the DA?
It means exactly the reason why we held the press briefing we held yesterday. Because we've always maintained, that if this country is going to wake up from the disaster it has been in the last 30 years of democracy, it needs to have political players who put their personal opinions and their ideological squabbles on the side, but get working in the best interest of all South Africans. And that's why we made a call to the president to say, Mr. President, you need to reimagine your seat as the president. You're not operating alone in Parliament, in government, in the executive. You need to take account of the fact that we too are there. And when you do so, when you make such decisions, consult everybody so that we can move. And again, we wouldn't be here right now having this conversation had the president applied the political maturity necessary that everybody's calling on, right? Had the president also been open-minded enough and honest to the counsel that he received to tell him that there is a procedural inconsistency within the act which makes it a constitutional inconsistency that must be corrected so that we can deal with the injustices of the past, so that we can still be able to democratically as a state be able to deliver a safe nation.
We're fast running out of time. Let's get some final thoughts. Lubabalo, what's the EFF's next step?
Well, we are going to go back to Parliament. So our struggle is two-pronged. We are going to back to Parliament. We'll introduce a state custodianship bill soon. We'll introduce a land redistribution bill soon to address some of the challenges that Bulelwa has spoken about. But the struggle may very well lie outside of Parliament, that people themselves must be made aware of the predicament we are in, and that all this wrangling between these parties, including the PAC now, will not return the land back to its rightful owners. So we're going back to the people to get a mandate from the people that the land must be taken, if not through constitutional means, then by all means necessary.
Ghana, how do you see this all unfolding in the next couple of weeks?
So what we want to say as Rise Mzansi to South Africa is that if you have a home, no one is coming to take your home. If you've got a farm, a land that's producing, that is being used, no one is coming to expropriate that farm. The only time expropriation will come will be in the public interest, to build a road, to build a dam. That's what the Act is. And we are saying this fear-mongering that's floating all over the place has to cease. And finally, the president derives his powers from the Constitution.
Thank you.
We have said, as Rise Mzansi, in our first statement of the year, that we want the president to show leadership. And the president must continue to show leadership based on the powers that the Constitution has given to him. Anything else, the politicking, we are not there. The president must lead.
Eddie, what's on the land reform minister's priority list given this Expropriation Act being signed?
We are fast-tracking the process of making sure that as soon as possible there will be a redistribution bill and many other bills that will talk to this question. We understand that this current bill still has limitations towards what these fellow comrades of ours want. They want us to go on a full scale, and that is the whole ultimate goal. But please appreciate the democratic setup we're existing in. Screaming and shouting outside Parliament, and that is just politicking. The core business is what you're talking about. You are saying to us, you will be bringing bills to the table. Then I'm happy. Let's avoid sloganeering, bring the technicalities, we talk to the question of the land.
Contentious issues. NHI, Expropriation Act. Will the DA still be part of the GNU after the Cabinet Lekgotla?
Yes.
No, listen, hopefully we'll still be there. Because ultimately we said as the Democratic Alliance that we entered this GNU to serve the best interests of South Africans, to make sure that even if it's 31 years post a democratic dispensation, South Africans can finally have a government that cares, a government that's able to grow the economy, to create jobs and alleviate poverty, a government that has an infrastructure that works, infrastructure that is of healthcare, education, or anywhere else, a government that works on evidence-based decision-making. We still are yet to receive evidence in Parliament of how the NHI is going to be funded without plunging South Africans into more financial distress via taxes.
We'll have to leave it there. Thank you so much to all our guests. Time is never on our side, but I think a value-added perspective matters. So thank you very much indeed. Digital audience, thank you so much for your time. Always appreciated. All right, before we go, here's my take. Look, consequences are in part a function of speed of process, right? How do we make sure that this process is fair, one, and happens at a pace that benefits those who deserve it? The land debate is no doubt polarized and vehement. The sentiment, you heard it tonight. And just remembering some of those views expressed in the build-up to the bill being signed into law, and you get a sense that when you dig a little deeper, in many instances, you find that the issue of land has a lot to do with equality and dignity. So the question becomes, how do we move away from the notion that there's going to be winners and losers at the end of this process, and move towards the idea of nation building through this process? And that's my take. If you miss anything on this program, be sure to watch this episode of It's Topical on YouTube. Trends Travel up next. If you're watching a repeat of this program, then as always, the news continues. Until next week, my brothers and sisters, take care. Bye-bye.